Critical to have an intimacy coordinator. I think that like you coordinate stunts, you coordinate dancing. It's choreography. So to be able to say, this was what happens here, here, and here in a stunt, and this is what happens here, here, and here in a dance. But like now you guys just go be, put your bodies together and your mouths and whatever, and just like action and cut. Like that's sort of ridiculous. So I think that being choreographed is critical for everyone's safety.
Welcome back to my channel. Today was the day when he was hearing New York between Black Lily and Justin. Don, well, not only they were there. In this representation of multiple parties, hearing and today were there. Talk about this protective order, Blake. The aisle party wants a specific. The designation called only legal eyes, which we will immediately refer to as a EO. Living side wants to protect what they mark as a certain confidential information they don't want public to have access to, but not only a public they do not want lawyers for us to make both side capable of share information with clients they represent about the discovery that to receive this is highly specialized, the type of protective order that is commonly used in cases that involves the trade. The secret in business cases can also be used when it is highly intimate information between competitive parties, which are on the market is not commonly used in such cases, but in this case, they want more than what the judge has suggested and what the judge suggested. It's basically quite complex. Already gives them a regime for searching and confidential designation and also gives them a regime to look for more, if necessary, on a position of cases live wants, and a EO blanket that can be marked third parties and alone without. I have to go to court to get him now. What I just want to start by saying is that Judge Lewis Lyman is seasoned judge in New York Southern District. The court seems to understand exactly what is this case, and he knows that this is a case between a dispute among PR companies is a dispute between PR companies. A dispute between the public relationship and the reputation of Belden and his friends. One side and Liv and Reynolds. Another is the case about fighting over the reputation. Don't be disappointed. This is not, at least in my an opinion, on sexual harassment, and the judge explained that these were disputes between PR company believes is proposed a protective order that is its standard, the problem and its model that gave them together enough and wanted to know why more was needed. So there was the arguments of all parties here, lawyers for Leslie Sloan and Vision and her Vision PR Group, Stephen Jones and Jones Works PR Wayfair, who represents Melissa, Nathan and Only Able, who are Mark and Have Your Own PR, and they formerly he was with Stephanie Jones, and then there was a New York Times, but they really did not argue anything, and Wayfair, so the real angle of the PR team are trying to get that they are trying to say it because they are competitors. They do not want to share information. They are suing each other, and yet, each other. It's pretty wild if you think. They sue each other, but yet they don't want to reveal any information about who their clients are, what they're talking about with their clients, what are their proposed marketing plans, can be the way they sold it, and a lot of it had to do with things that were not even relevant in case. Incentives. Stephanie Jones, a lawyer for Jones Works, said that I don't want to turn confidential information to former employees or trade secret business plans are they claim would now be a competitive injury. The reel of that nearly 2 hours. 2 hour descended to a really dispute between Live side and Page Wayfair and Live. The party directly from the gate came out very much fought and put on very strongly that they believe their lives are danger. It was very performative, as someone listened to if I were on a Jew and I had to decide on the basis of what did they say. They provided zero evidence to claim that they are due production, and it seemed to me as if she knew many ways of talking with the audience. In my years, I have a report. I have sat in dozens of cases involving real crimes of tired life Crimes Against Children essay. People who download the child's content or Sam, and we heard, and we had to read some of the most disturbing complaints and documents in court. Real crimes and my opinion of listening. It was that alive and Reynolds are. Misleading tries to equalize and civic. Such a ruthless ignorance. A system of justice that frames your lives will be killed. Be killed if you hand over the discovery. Trying to say that if so, pass the information that will be killed, maybe damaged reputation, but attempt to place this metaphor or this way. The dead body vision felt so ruthless, irresponsible and deviant because and careless, ruthless and harmful to real victims because if you have followed and criminal case and someone was like, well, I cannot provide this information because I am in the case of witness and go. If your case is kill, well, yeah, it certainly includes capital murder, but that is civic case about reputation. Made me feel like the same ignorance have for victims essay, actually for all victims of crime, and sees each other and what is happened to them as some kind, like deep persecution and deep insults, and the injury they consider it like life or death, and that seems to me incredibly irrational deception, and unconscious and narcissistic in all. Their arguments felt very much. The whole point was to frame Justin and Wayfair and Boney and Brian Fredman as dangerous, and the judge had actually remind her of her lawyers that there are absolutely no not an officer who is sworn to his judgment and observance of civil laws and oaths. Court. This would harm another CL, a client of a person who would physically harm the security of this person, and that there was no reason to believe that someone was physical security risk in this case on the basis of claims. The court and behaviors so far clarified that these types, this direction they want to go, will not work down, try to go down in this line, that if they give up, the discovery ends up dead. And the judge was as if we were not buying it. And Freeman will not hurt you. Wayfair won't kill you, no. One dies and was ton. Back and forth about what details from this protective order would look like. It was very clear to me without giving you like a wound of all too. The clock that Lively is the main problem is that there are interviews that she and Ryan had his celebrity friends and information that is are happening in these interviews to believe that they would harm their reputation even further and look very worrying that any details of the serious illness and information about mental health, about the children and their home position, they would endanger their lives. Using such dividing and dangerous tongue felt so overdramatic, and I understand that they are trying to make looks like this is like this immediate need why this information needs be protected, but to compare civic discover to life or death cannot go. Work at a federal court judge already has a pretty decent protective. The order and the judge spend a lot time with Lively's attorney's attempt get them to turn it out of it. The concept that people get injured to the extent that he said and defended Wayfair as lawyers and said, as if I didn't believe they were these lawyers, hurt someone whom I do not believe. They will violate a court order. If I rule someone, I believe this. Lawyers, and you are going to follow these rules and do not go. And if they break it, we will hold them in contempt, and he said that I do not have a problem with holding people in contempt, violating, and did not like them either. Concept that if someone has broken something that could be held in contempt, they wanted it like no information. They could go out, they didn't want to. Talks between Black and her celebrities' friends have become public because they have clarified that Blake, the whole brand Rihanna is based on sales, boys, picture, and if you knew what they say behind the closed door of their reputation would be damaged, that it was not a super convincing argument, quite honestly, because in court your action claims your reputation has been damaged, and when you 5 a prosecutor to which you are going to a court at a public court and has submit documents and judge. Very clear that if this case goes to the public, if they go to the proposal, a summary judgment that is made if they are feel like it after the discovery, and the discovery shows them that case claims have no merit, may try to learn about the case, the judgment of the complaint, or in terms of attempted this discovery that is provided, there and back become part of this summary judgment or testimony or evidence in court proceedings, and so they cannot simply protect the conversation between Blake and her friends celebrities in a public court in terms of court, and he literally said he would not close his court will not close the court. There are strict rules and laws that and be a high-ranking person means you get some protection. The court said there was a public interest in how the courts are used, and as they rule and drive cases, and is the right of the public to know about what's going on in public. The court, just because the information is shared in the discovery, that does not mean that automatically becomes the public, because not all discovery becomes public. In any case, and that is the meaning of discovery, and that they already exist, judgments and already exist, protection in modif in order, that he has to sign a document that says they can't release any of this information or otherwise they will be held in contempt. And then had Lively's lawyers had to dial it a little like good. We don't want any of our interviews to get out. We don't want to know that about our public health or our mental state. The health they don't want is not about it. That if it's already in public, it's okay. We're not trying to prevent the public to have access to. We're just trying to protect that third party. We want to help the court and the cost of court and assistance. The public spends less money on it because when you go to court, by the way, dollars of taxpayers, said the judge, that no, it depends on how they order it, and no matter which protective rules will select, they will have to go to the judge, no matter what they do, because it is the judge's decision to determine what will be very confidential. And what isn't it, he literally said. During this hearing, he created an order and said he would not sign any protective order. That definitely information confidential that's submitted to the court. So any submission and any suggestions that have submitted will not sign anything to protect. That he said the law must be followed, that there was no protective command at all for what is happening in court. Will not close any hearing that will not be. Close a court must be public. It doesn't matter to a high ranking or not. Then Brian Fredman was able to give its side of the story or species, like why they think this protective. The order is unnecessary and started. A little frustrated by how alive is. The party argued and noted that he found that he was super offensive, that yes, to accuse your side or even a party, wayfair violation of the court order and to propose to the court that it would break the court order. It is nice. Offensive to say that, and that he believed that the current command or the order of the court protest was enough to protect people, and what he says, the assumption of their protective rules, and their arguments were that these people believe that celebrities they and the powerful get should be treated differently in court, that they should get more protection than you or me if we went to court, and that's because they have celebrity friends and have more money that get more protection before court than we, and if they're like arguments around PR company that said a lot. Their arguments are simply ridiculous because PR companies advertise. They speak themselves with publications. Everyone knows who their clients are. Everyone knows these agents are talking. On the media, actually, yes. Text messages of these PR people to tell publications who are, and the information they provide to these publications, and that none of this is actually a secret, and that would not be considered confidential. Information about it discussed how information Lively party was provided to a New York Times. It was confidential, and so, to say for them to provide confidential information into the press when it has already been done, quite hypocritical, and quoted it. The New York Times claimed that they refer to have been checked by thousands of the pages of documents that continued, that it's not like a big company. Cases when it's like Texaco versus P&L or Microsoft versus Apple or Coke versus Pepsi, where real trade secrets. They go back and forth, it's PR. Companies do not want to give up information about people that publicly advertise the same, but said it's absolutely unnecessary, and he stated that they are not interested in publication of confidential information. This is already protected under a protective order proposed by a court, as if they were not throwing away medical records or to issue private information about business. May not get to justice, as he says. There is already a decent system with the protective order and spoken about this security concept. Guards, and there's safety, and he says no one is interested in what someone is not doing. The security remotely relevant to the case is a ruse, which is used by lawyers. Lively and not relevant, does not know why they are even raise it or why they are solve it in court, and then the medical records of her Lively and psychological records will be needed to prove damage, but in terms of discovery, may pass through a process that needs to be maintained, is confidential, and already exists, built in modality within the protective order to be able to go to the judge and look for a higher level of confidential. But said they don't have interest in security is nonsense, and the only people who were stated in this case, which is the third parties, are leading from Sony society. They never actually said who they were in their complaint, but live in her complaint 3 times. So and a lot of what he pointed to was like, they blame us for violating their confidentiality, yet they're they that continues to violate our confidentially. And their other concerns is that the current order that would live vivid get them to have to go to court constantly, because they would be automatically capable of to mark everything as the eyes of a lawyer only, and then it can be abused, and so this increases costs and DRI, and it gives more pressure on the court, and it is abuse of the judicial system, and that burden, whether something should be more protected or not, fall on him, but falls on them and puts a burden on them, fight them to go to court and get a judge to rule if they automatically get. It was also something else. Arguments about this paragraph about could not share information over the internet, that he said he was ridiculous because there is third parties, because it would prevent him from being able to send email his own colleagues, and a little there was more back and forth about security, the guard, and then they said, well, why did they summon security team and you have to download your summons? And when they talked about security, I think the reason that security, and if it is who I am, they think they say that the conversation with Justin has become the front of her driver, and I suppose that maybe the driver is part of this company that is not just a security, but also a driver who is the only one thing I could assume that therefore they receive information, but maybe Blake's side causes it to look, trying to disrupt and reveal details of security, a lot of that. He felt very like her side was the gas world, and on the side of Fredman it seemed to be, because the living side went first, was on defensive and had to defend a lot about what they said, and that too. He felt as if the New York Times was trying be on the side of Lively and act like everything that claims Fredman is as fake, and at one moment the judge had to remind Live side and the New York Times that everything in this case on both parties are accused, and each side has the right to raise accusations against others, and it's up to court, and the court itself ruled on what the truth and what is false and so they don't get. Say that Justin actually committed. Things are accused of not. Say it happened as a reality. Because right now it's just. Accusations is not a fact, and they don't be said to be just that. Accused of judges, I have been as. Well, you go, you know that he held. Remind Lively's party that exists. Claims on both sides of both sides, yes. Has demands, but so does Wayfair and this concept that happens. Or reject the case against Wayfair. I don't know about the side of the New York Times. I know they made a proposal. Release, and I know that he is. Discussion of the amended complaints. It could be done to try to remedy again some problems that New York Times induced in their movement on release, and I would not be surprised if the New York Times will be removed. It completely, because it's extremely hard to sue publications in the United States and really succeed, but what? It seems to me that the judge was quite clear that it is not even party to say that the parties are frivolous or bringing frivolous suits. Decide what the court will decide what it is rejected and what is not, or the jury will be decide. As far as the court is concerned and inwards, sincerely to be a slam, well soak. We are just going to make a proposal to reject and disappear. It seemed to be repeated again. This is not given here, and in my opinion, and I went through the courts, in itself is incredibly hard to win, and a proposal to release at the beginning, because the judges do not like to release cases, because if for some reason they will do it wrong, it can come back and bite them, and you have to allow court, the procedures of the court, that you have to prove why your claims are false. Discovery, and through a summary judgment, or through an attempt, but just try. Discard it, because you don't want to. To deal with it, it's hard to the New York Times has the best opportunity to get it. Throw away, I don't think anyone else had a good opportunity to get the case released before it gets into the discovery. And I feel it is that they are. We ask for all these protective measures to discover that all parties be aware that it will probably be should not be released before it goes discovery, and in summary, a judgment or court. If I were to be betting person on how the judge will be rule, I think there will be a kind. I think the meeting of the center will be a certain level, and only the designation of the eyes of the lawyers, but it won't be to the extent Live wants. I don't think she's going be able to protect conversations with your friends, and she won't be able to protect the conversations fair, because it will damage her reputation. I think it will be much narrower than what she suggested, and I think they will have to come with something that can satisfy both sides so that the process of discovery can. It happened that the judge basically ended it. Say that he will take it under sending, which means he will rule about it in the future. But he ended quite strictly, which yes. No, I would say go in favor of Alive, because he said that this is a case where there is a lot that was published in public that has a ton of attention of the public, and there should be no confusion about what's going on. The court means not, there is no, will protect them because they want. In order to be protected, the public cannot be confused by what is happening in this case. It must be public, and that there is a assumption in court that was defended and is in that priority. A district that the public has the right, have access to the case, and have the right to know how the court is used, so it is very clear that it will follow what is consistent in his district, what is normal for these cases. Will not rule, because someone, celebrity, and he will protect the public interest above all, because of the law. So I think it will end, it happens that it will be in terms of a certain level. The eyes of the legal representative will be very, very narrow, not as wide as it wants, and certainly not just to protect her private conversations with Taylor Swift, because it could hurt her. The reputation was mostly a lot. Livid Tories Cuddy's claim, and if you want the impression of both sides, Brian Friedman comes very original. It seems that. Be very honest in your representation. He seems to be fighting for his clients did not use inflammatory. The language was not negative or the derogatory, and the living side was very inflammatory, very not to. Court extremely disrespectful to side of Wayfair, and if you should ask me based on how the lawyers were done, I would say that it is not really alive. Have a case because of the way in which the lawyers acted, but that is just mine. And I was sitting again. Many judicial cases, I believe only, based on how Brian manipulated in court that he is really good dude and does what is for his clients and that they are to defend their and he will defend them and is that they feel as if they were bullied. So he felt you knew my second. The thing I want to say is that I think there is a severe mental illness. I think Ryan or Blake is seriously mentally ill and tries to prevent the public from knowing. I think there is either a substance abuse is happening or something is. This is unhealthy in that marriage. They don't want the public to know that. But they still talked about mental illness, and I think one of them is seriously mentally ill, and I think it is correctly obvious how they are acting and do not want the public know what is weird because they are trying to say that it were damaged by these people and they thus trying to make claims to damage. Tell me, what are your thoughts? The comments below. Make sure this video thumbs up. Make sure sign up to take my channel if you haven't done it. Sign in and click the bell so I will never miss much. Thank you very much. Watch how Tell Me Things. Hi.